very beginning to say that I am the chairperson of the arbitration class with Michael, Mr. Michael Mapabi, who's a partner at S&L Advocates, and Ms. Florence Nabweteme, who are both arbitration practitioners and my colleagues at the cluster leadership. We are grateful to the ULS. We've had very kind access from Godwin, especially. I want to acknowledge that for the membership to know that Godwin has been very instrumental in assisting us put this webinar together. Which brings us to why we're here today. We have a fantastic panel. I'm very excited to be moderating this panel, which has Mr. Mohamed Mbabazi, who I believe is the most senior of us all, an affluent arbitrator in his own right, and a prolific litigator of many years of standing, but I will let him say more about himself when the time comes. We have Mrs. Anne, damn it, and second name, Namara Musinguzi. Anne, you have to forgive me. Mrs. Musinguzi is one of those very aggressive litigators and has participated in litigation. I believe even in one of the matters that we're going to discuss today. We have Mr. David Kagwa, who is a partner at Kagwa and Kagwa, but also is the current president of the Ugandan chapter of the Canada Institute of Arbitrators, an arbitrator and an arbitration practitioner in his own right. And then, last but by no means least, we have Mrs. Robina Shonubi. I have the unique and enviable privilege of saying that all our panelists today are my dear friends. Robin and I was talking to her yesterday and saying that I will tell the people that we've known each other only 20 years. Robina is very keen on mediation, arbitration, and she will say a bit more about herself just now. Our subject today is on the recent decisions on setting aside arbitration clauses. Where is the wind blowing? What are the courts saying? But we thought that we would take a bit of a broader approach. So Robina is going to kick us off on, let me just run through what the layout looks like for our audience to follow carefully so that you know to stay to the end. We will start with a discussion on really the foundational issues. Arbitration clause versus first meeting and how that affects setting aside, what are the principles of setting aside. And then from there, we'll go into bias as a ground on its own, and then what are the other common areas. Our panelists are prepared to the teeth in terms of what are the recent decisions and what have the courts been saying. The format we are going to use is such that every panelist will speak, and then after they speak, we'll do the Q&A for their session. Then we'll move on to the next panelist. So if you are on the call and you have questions for a panelist as the discussion goes on, please drop the questions in the chat. Michael, Florence, and I will be tracking the chat to make sure that we leave no question unanswered. We will not have a Q&A session at the end, because you can imagine if 1.5 hours from now, you have to ask someone a question later, it's going to be a bit tricky. So again, for our members on the call, please drop your questions in the chat. We will be tracking the chat to make sure that we see what's happening there and raising your questions. Without much further ado, it is my singular and enviable privilege now to pass you would say mic, but in this case, perhaps pass the tile to Robina to take it from there. Robina, over to you.
Thank you very much, Robert. It's a pleasure to be, and I hope I can be heard because I can't hear myself. I'll just say a few things about myself. If somebody woke me up in the middle of the night and asked me who I am, I'd probably say I'm a Christian, I plant churches, I preach the gospel, or I could just say, well, I'm
Oh. Robina, I think you're muted for some reason. Godwin, can you hear Robina? Robina, I think you're muted.
Oh,
I think she muted herself. If she could press again.
okay. So should I start right from the beginning?
Yes.
Is this the first time you're hearing me? Oh,
no, we had
so sorry.
And then you cut out. Yeah.
Okay. So should I just start from the beginning or should I continue?
I think let's go again.
All right. Okay. So thank you very much, Robert. I'm really honored to be in this August assembly. If somebody woke me up in the middle of the night, just to say a few words about myself, I'd probably say, hey, I'm a Christian. I preach the gospel. I plant churches. I've been doing this for 25 years. Or I could just say I'm Mrs. Robina Shanubi, Alan Shanubi Senior Counsel, Triple Paul Harris Fellow is my husband, and we've had a very fruitful relationship. I could also say I'm a mother and a grandmother, and I could just crown it off by saying I'm a social scientist with honors from Makerere University. I'm a lawyer, LLB honors from Makerere, and I have a Master of Laws from Fordham University down in Manhattan, right next to Trump Towers, near the Lincoln Center. That's where my law school, School of Law, is. I wanted us to orientate ourselves to what arbitration is, because it's one thing to talk about arbitration clauses, but I just wanted us to quickly run through what an arbitration in a commercial setting is, because after you've drafted your contract, the last page would have a little title saying dispute resolution or future disputes. How will they be settled? So what the partners or the counsel for the two parties or the three parties who are in the contract do is they'd have to sit down and think, okay, what is arbitration? Why would we not go to court? And then somebody would say, well, it's faster, it's cheaper, it can be very efficient, and it saves you a lot of time. And then somebody would say, that sounds great. What else? And then you'd say that you have an opportunity to be involved in the procedure, in the case management and the schedule order, because it's not like how you're stuck with the CPR in litigation. And so once the parties agree that, yeah, let's go for arbitration, that's when they have to draft a clause at the bottom of at the end of the contract before the parties sign. So it's really important that everybody understands what they're getting themselves into, because a proper arbitration clause will have mandatory clauses that impose a contractual obligation on the parties. And that obligation is, we're only going to settle our disputes through arbitration, no recourse to the courts, no recourse to litigation, and therefore they have to make it work. They have to protect that award, and they have to try to work together as best as they can. So I wanted us to have a look at two types of arbitration clauses. You can have an arbitration through an organization, like in Uganda, we have ICAMEC, or you can have the London Court of International Arbitration, LCIA. And these organizations have standard arbitration clauses. And there's one here by Practicum Law Arbitration, and I'd like to read it. And I'd like you to listen for the words that actually lock you in, that leave no room for doubt. And it says, any dispute arising out of or in connection with this contract including any question regarding its existence, validity, or termination, shall be referred to and finally resolved by arbitration under the LCIA rules. So that's a standard clause that if you insert it at the bottom of your contract and then the parties sign it, if anything goes wrong, you automatically get onto a plane to London and resolve your matter with that organization, helping you choose the arbitrators from the list they have or approving somebody you insist on. So it's all very tidy and you don't have to argue about money. They work everything out for you, although you still have to pay. Another type of arbitration clause could be from an ad hoc, is called an ad hoc arbitration clause. For example, the standard recommended arbitration from Arbitral would go like this. An ad hoc meaning that it's not controlled. The arbitration clause and its rules are not controlled by any specific person. You choose who's going to control or use it. I know these Arbitral rules and laws are developed at the UN. Your country sends a member and members develop them. So the ad hoc rule from Arbitral clause is any dispute, controversy, or claim arising out of or relating to this contract, validity thereof, shall be settled by arbitration in accordance with the Arbitral arbitration rules. And then you can add the appointing authority, who would be somebody else. You can also add the number of arbitrators. Do you want 1? Do you want 3? This is a good time to think about that before the contract is signed. What are the qualifications of the arbitrators? Do we want engineers? Do we want only lawyers? Everything depends on the contract, which is now fresh in your minds and right before you. And then you decide where the place of the arbitration will be, what town, what country, the language. And as arbitrations become more complex, people want to break it down even more and add details like the kind of counsel, the kind of lawyers that we want to arbitrate this matter. Would it be the lawyers who have drafted this contract, or should we outsource counsel to assist the in-house lawyers because we need somebody who's experienced? Arbitrators are very specialized, and sometimes if you get a litigator who is used to arguing cases, open court, there are people passing by, their style may actually be counterproductive. So it's important for you to agree, even in the arbitration clause, that you will get counsel. You'll outsource if you don't have the skills, somebody who is used to working with arbitrators so that you get the desired end, which is an award. Now, an award, if you are in court, you'd get a judgment. If you are in mediation, you get a consent judgment. But in arbitration, we get an award, and that award is normally money. During the scheduling, you can agree whether it's going to be reasoned or whether you just want to know how much it is. After all, the lawyers were there, they know the details. But many people insist on the reasoned award. So that's what arbitration gives you. It gives you the money. And so when I said that the arbitrators get kind of agitated if isn't sensitive to their expectations, it's important, even if you can't outsource an experienced counsel to lead your side of the arbitration, I think it's important for everybody to participate in the pre-scheduling of the arbitration, because then you actually meet the arbitrator and you can gauge what kind of person they are or what kind of people they are. And they can also tell you their expectations. They can tell you how they handle evidence, that whether they're stringent on evidence, whether they're not, how many adjournments they expect, how much time, deadlines, all those things happen in the scheduling. So it's important, even if you're not a seasoned counsel who handles arbitrators in an arbitration, you should be able to pick up on that and be able to work together. Because at the end of the day, we're all here for the client. Our professional ethics, our paycheck, everything is about the client. So you want to do your best for them. And part of that includes working well with the arbitrators. There was somebody who talked about a pathological clause. And just by the word pathology, I know it reminds you of some of your friends in medical school. It means that you've drafted a clause which is dead and it's not going to make it through the process. So to avoid a pathological clause, you should produce mandatory, you should have clear words like shall and not leave any vagueness, so that when the dispute arises, you just hit the ground running and start looking for arbitrators to suit what you stated in your arbitration clause. The arbitration clause should also exclude the intervention of courts in the settlement of the dispute. So you should make it clear that there is no recourse to litigation or the courts. And then also the clause should give powers to the arbitrators to resolve the disputes that are likely to arise between the parties. In some jurisdictions, the arbitrators can actually grant interim measures. So you can actually state that, or you have the inherent powers of the court. The court can help you get injunctions, specific performance, whatever is required depending on the nature of the conflict. Your arbitration clause should permit a procedure which leads, under the best conditions of efficiency and rapidity, to the rendering of an enforceable award. So one of the ways you can have an award that's not enforceable is if the arbitrators themselves are acting in a prejudicial manner, a manner that can almost be called misconduct. And there's a section that will be discussed in detail later by somebody else, section 34 of the Arbitration and Conciliation Act, which actually is designed to help parties who have had the grueling experience of an arbitrator who doesn't allow adjournments, doesn't allow the other witness who you're insisting on, so, and then also if he's biased, seems to prefer them, everybody notices it, seems to, and yet you don't understand why he prefers those people. That's called bias. And an arbitrator is supposed to be neutral. The only reason why they're sitting there, why they're chosen by you, is because you thought they were neutral. And the definitions of a neutral person obviously include impartiality and on top of being qualified to deliver an award. So I think for now I'll stop there, and I hope that gives everybody an introduction of what arbitration is and how to be careful not to miss the point and just, muddle along and in the end lose your award because you were not careful in the beginning. So the beginning always matters. It saves time, it's helpful. And maybe finally, if I have, Robert, how many minutes do I have?
So I think you're good for another about 4 minutes.
Okay, I just wanted to mention something that Senior Counsel Alan Chinubi told me to suggest, is that there's a difference between arbitration and litigation, and these differences should be exploited. Counsel should recognize the many differences between them. And I've already talked about the fact that there's no jury or anybody to showboat for, and that arbitrators are generally experienced and sophisticated professionals with whom posturing and grandstanding are almost always inappropriate, counterproductive, and wasteful of the client's time, money, and credibility to sense the mood and not to try and get your own agenda. Because remember, an arbitration is a private hearing. Sometimes even the way the arbitrators and the parties dress, the dress code can be very casual. And the idea is to help the parties get an award. It's for the arbitrators to hear the evidence, the witnesses, the documents that are submitted, so that they can channel them into a process that gets them to give you a fair award. And by the way, there's no such thing as a fair award. Whatever award they give you is what it is. Thank you very much.
Thank you very much, Robina, for getting us off to a fantastic start. I'm in a room with someone who said, I like the way she's just really simplified the whole thing. Just so you know.
Thank you.
I think you've done a fantastic job. And you've set us off onto the point about the differences between arbitration and litigation. Mm-hmm. But you also have us really well there on the principles. You touched on section 34. And so yes, from there, this is, I think, a really good time to bring in our senior counsel, Mohammed Mbabazi, to take us through the principles. Because I think that one of the major distinctions, and I hope I am right in this, Robina, is that with litigation, there's almost an automatic right of appeal. With arbitration, you have got, really there is finality. The idea is that yes, the appeal is the exception.
Absolutely.
Now, one way to get around that is to apply to set aside the award. But the principle for what happened, for how you get to that position, is where now we jump in. And over to you, Mr. Mohammed Mbabazi. I am very privileged and excited that you're joining us and taking us from here.
Yes, thank you, Mr. Kirunda. Mohammed Mbabazi is my name. I'm an advocate. I will not go into the grandfather and mother and all that stuff. I'm just a low-profile advocate. Mr. Kirunda, am I being heard?
Yes, Mohammed, I confirm that we can hear you. Yes, we can hear you.
Good. So I will go into the principles of arbitration. And to me, the principles, to understand the principles, you just need to know, I'll get the principles from the differences in arbitration. And almost, we need to know that arbitration is a method of resolving disputes outside the traditional judicial court process before a neutral third party. It is not like you, maybe these days it seems to be like, because you find an auditor, an engineer, and any other professional being an arbitrator, people think that two advocates, one for the claimant and another for the respondent, agree to have an arbitrator, the neutral third party, and probably fleece, sorry for the word, but fleece their clients, such that, of course, as an advocate for the claimant, I get money, an advocate for the respondent gets money, and the neutral arbitrator gets money. No, it's not that. It is a recognized dispute resolution method, which is outside the traditional courts. And its core principles are: one, it is voluntary. It is not like a lawsuit, which is mandatory. You find yourself there. It is voluntary and deriving from what Mrs. Shunubi has said, people sit down, draft an arbitration clause, and agree on all the things that are going to govern their dispute resolution. So in that regard, as a voluntary method of dispute resolution, it is also informal. Why is it informal? It is informal for purposes of being efficient, effective, and a quicker method of resolving disputes outside the judicial process. And in that respect, it is even more cost effective. It is more cost effective. I will not go so much into the informality. I can just caution it is less informal. Doesn't mean that you will come up with all the evidence, which is even here say there are ways it is regulated. So that is the other core principle. Then the other principle is on choice of an arbitrator. You agree to have an arbitrator. You say, Mr. Kirunda is going to be our arbitrator. So that brings in the aspect of what they call party autonomy. Party autonomy. You have the ability to select an arbitrator in the court process. Unlike in the traditional court process where the judge is assigned. I think you, with ECMIS now, you know how the judge is assigned. The other core principle is confidentiality. Confidentiality, you can keep the proceedings, the award, everything confidential. That one I need not to go so much into it. Then the other one is the finality. The parties agree that now that finality principle is the one which now brings in why we're here. And I would think it is now bringing in the clash between the arbitral process and the court. So the people, the parties agree that this is final and binding, and they will take it as it is with limited rights. And the rights are not for appeal, they are for setting aside. They are for setting aside, as I will discuss. And then the costs, you agree on the cost, you can say 5,000 and you share it. It is not like in litigation where you pay for your fees and then the arbitrator, rather the judge is paid by the state. So with those principles, voluntary equals party autonomy. Informal equals flexibility. Choice of arbitrator is party autonomy. Confidentiality is confidentiality. Finality is the finality principle. So if you know the core principles, then we'll go to how the courts ought to balance the principles of finality and party autonomy versus what the courts want. Because when the courts come in, they don't come in as appellate courts. I think that one we need to understand. They just come in to ensure that there is fairness and substantive justice. It's actually not substantive justice, it's procedural justice. Because as an arbitrator, he is allowed, like any other human being, because even the courts have judges who make errors. If he makes an error in the context of the law, that is supposed to be allowed. It is only when he makes errors that affect the fairness. That's why when you look at that section 34, we are not looking at section 34 is not about errors of law as such. They are looking at fairness, which starts from, is the arbitrator, was the arbitrator impartial or he was biased? He can be biased by, and I will not go into that so much because there's somebody who is coming in to say that. I'll just show that if he's biased, he's seen as being a neutral third party. And then, of course, there are issues of public policy. There are issues of composition of the tribunal, then being procured by corruption or fraud or undue means. Now, that interpretation and application of those, now, the real judges would call it balancing. How do you balance the balancing act between fairness, ensuring that there is fairness, and ensuring there is finality? In this webinar, we are so much into the recent cases, including the one of higher investments and industrial development. But there have been others. I think higher investments, one, it brought out those issues, those principles to me. And of course, at the end of the day, the judge said he could not, this was not a matter which was justiciable before the courts of Uganda, at least in the first decision. The second one, of course, the reasons he used for enforcement, which is still the same. But this one, as regards applying to set aside, he said, well, the law. But if you look at it, he really brings out the principles. And if I may quote, he says, arbitrators are contractually empowered to provide the parties with a definitive interpretation of their agreement. It follows that parties are bound by an arbitral award and are obliged to abide by and comply with it. The substantive issues which the arbitrators determine cannot be subject of review by the courts because arbitration by nature is final, is showing the finality. And to my recollection, this was the earlier attitude of the courts. If you go into cases of, the two cases of arbitration, which we have in our jurisprudence here in Uganda, not the East African context, we have oil seeds and NSSF. Oil seeds spent almost like more than 15 years in court. And it was just on a small issue. The first time it came to court, the judge refused, said, no, this is once the arbitrator has made his award, the courts don't have any mandate or jurisdiction. That one went up to this, and then was the Court of Appeal. They said, no. The court has powers, and the limited powers it has must be exercised by balancing the finality principle and the fairness. Can you remit? We remit it to another judge to hear it, to hear the chamber summons. That was in the old case, rather in the old act. It came back I think it was resolved somewhere in the 2000s. If you look at, from there, you have the NSSF Act, the NSSF and ALCON. If you see the judgment of Leta Raj, she really did a very good job. She balanced, and actually the arbitrator at that time and the arbitral process must have been proud, because she really ensured that, well, you can go for arbitration, get your award, and it will be protected. It is final and can be enforced. But of course, afterwards, it went for a court of appeal upheld. Then it went to the Supreme Court. I think Supreme Court, it was up and down, until finally it was, I don't know whether it was set aside or it was remitted. But if you see the time, one, all the principles, the core principles of arbitration were lost. The confidentiality, the finality, the voluntariness, the informality, all of them were lost. People were talking about illegality. So, Mr. Kirunda, how much time do I have?
So, Mohammed, I think you are good for another 8 minutes.
8 minutes, yes. So, the two cases, that is the oil seeds, after not two cases, because there were so many awards and judgments that were done, bring to the fore that the courts at that time really were in for the arbitral process until, I think, to me, when the Court of Appeal came in, rather the Supreme Court came in with the NSSF and ALCON judgment and decided as they decided. One other judgment, I think, which, just for hindsight, which discusses those principles and how the court should act. I will share it with the Secretariat and they will forward it to the cluster. It is Tropical Investments Limited versus Jimmy Mukasa. This was a judgment by the former PJ Justice James Ogola. He discussed, there were so many grounds which were raised: bias, incompetence of an arbitrator, and in his analysis, he said that, one, he was not going to become a court of appeal or an appellate court to set aside the judgment of the arbitrator. Of course, he was conscious of the finality principle. And he says, but even if the arbitrator's conclusion had been a misreading of his discretion under section 56(2), still the position appears to be as set forth in that name, Masteel Commercial. And Masteel brings out the principles and is actually saying, courts, please don't disturb what the parties have agreed. Don't disturb what the parties have agreed. There is party autonomy. There is party autonomy, and of course, the other principle is finality. I wanted to read out something he said. He says, by agreeing upon arbitration the parties have removed the merits of the dispute from consideration by the court. By agreeing upon arbitration, the parties have removed the merits of the dispute from the consideration by the court. And he further says, the application to have an award set aside is not in the nature of an appeal, nor is it a review of the merits of the decision. The parties have agreed not to submit a dispute to the courts, but to be bound by a decision of an arbitrator. So from my analysis, I think we need, as we look at these cases, as my other land friend will continue looking at analyzing the different, I think the courts have to really go back to that position. That position. I'm not saying they go back to the position of oil seeds where the judge said, no, we're not going to handle any award, whether it is setting aside or no. We're saying, look, these parties have agreed. They could have made errors, but if the errors are errors of law, please, like they also make errors even at the Supreme Court. These days, I have seen the sleep rule, as people do sleep rules 4 or 5 times, and the judges still listen to them. So they make mistakes. So let them just ensure that there is fairness. Fairness arising from, was the arbitrator biased? Yes or no? Determine that. Was the process fair? Yes or no? Public policy, but then even public policy should not extend. Public policy is nowadays extending even to illegality. Illegality is, I think, an interpretation of the law. But these days, even illegality is becoming a question of public policy. I think somebody who is handling public policy will manage that. Jurisdiction, the arbitration clause. So in my analysis, I would say Mr. Honorable Justice Mubiru, in his recent higher investment, he brings out all those principles. And although he did not apply them because the application wasn't, he found that they could not be applied. The jurisdiction was outside, but he set down the principles, and the principles were set down very well. If we can proceed with those, probably the arbitrators and the arbitration environment would be more conducive than to me than it is now, because I can see so many arbitration awards being set aside. I think somebody is going to discuss those. That is the beginning of Kilembe Mines. I think we have also graphics. Graphic Systems Limited versus Coil. The arbitrator was, I think, almost held to have been incompetent. The same as, I think, Kilembe Mines. Of course, this is without prejudice to the advocates who have handled these cases and all that. It is just now for discussion. Those are my views. Do I still have some more time, Mr. Kirud? Mr. Kirud?
Yes, Muhammad. I think you've covered.
Have some more time?
I think we are now going to use the time to jump into some questions.
Yes.
They do that in the chat. One person, our colleague Joel Osekeni, is asking and saying, some people argue that arbitration is ideal for particular disputes and not others, specifically that where the subject matter is below 20 million, arbitration is not advised, arguing that an arbitration is expensive for small disputes. Is this an accurate assessment? Can arbitration be advised for all disputes or specific disputes? But I do have another one for you, Mr. Muhammad Mbabazi.
Yes, I'm hearing.
Looking at section 34.
Yes, sir.
When you look at the wording of section 34, subsection 2.
Yes.
Section starts by saying an award may be set aside by the court only if. My question to you, sir, is can a court go beyond the premises of subsection 2 of section 34?
There's a section 34, 2,
yes,
A and B.
Correct.
I think those are the parameters.
Yes. So if a judge were to raise a parameter that is not specifically provided for in A and B, would they be right?
Of course, they would be wrong. They would, one, it is not according to this. And of course, going back even to section 6, where is section 6? Section 9, except as provided in this act, no court shall intervene in matters governed by this act. This act has set section 34 and said, please, if you are dealing with my awards under this, please confine yourself to this. Then if you go outside, definitely, I don't know whether that would be an error of law or fact. This is where we are supposed to end. But at the same time, when you are using the balancing act, because there are people outside there who are very much interested in using arbitration as a means of resolving their disputes. Anything that goes beyond or outside, you start telling the arbitrator that you see, you interpret the law this way. I think that is wrong. That is my view. I don't know what is the view of the other people. Have I answered your question, Mr. Kiron?
Yes, you have. Do you have, and thank you very much. Do you touch briefly on that question about expenses versus the value of subject matter? Is arbitration ideally cost effective if your dispute is 20 million shillings? Very briefly, and then we'll.
I think so. Arbitration is suitable for, because even the person dealing with the 20 is also a businessman in his own way. Probably he deals in a I don't think you saw them in Caravan, but at least these shops in the village, or at least we've been having this other court at LDC. What was that court? Below 10 million. If somebody decides and says, look, 20 million, yes, let us go before Mr. Mbabazi. Yes, Mr. Mbabazi, how much are you going to take? We'll give you 500 and another 500, that is 1 million. We sit down, our processes are informal, write a letter. You know, it is voluntary, one, and informal. I can sit down and say, look, this is a simple matter, I don't want to play it. Write a letter, putting down what you want, also write a letter. That is how efficient and cost-effective arbitration can be. It is so informal that the arbitrator can decide with this, with the parties. How do I resolve your matter? Then we just bring our receipts here, and for me, I have an accountant. He goes through them. Whatever he finds, I'm okay. By the way, that procedure is even in the CPA and the CPR. People can agree and refer matters to an arbitrator to resolve an issue which they think is small. I think it is. Probably 1 million might be too little, but 20 million, I think that is okay. You can sort it out.
Fantastic. Thank you very, very much, Muhammad, for bringing us this far. I just remind the members on the call, we will not have a Q&A at the end of the session. We are doing the Q&A for every panelist that we have. If you have a question, please drop it in the chat, in the webinar chat. We will pick it up and bring it to the attention of the panelists. Thank you very much, Mr. Mbabazi, for bringing us to this point. And I think that you've left us at a very good pivot where I would like to now bring in Mrs. Musinguzi. The word bias itself does not seem to appear in Section 34, but there have been decisions on bias as a ground for setting aside. Do you want to pick up from there and walk us through what the latest position of the law is on these issues? Mrs. Musinguzi, over to you.
Thank you, Robert. Good afternoon. Allow me to remove my video so that we don't have any internet glitches. My name is Anna Mara Musinguzi, as already introduced. Robert described me as a very aggressive litigator, but the other part of me has a very passionate heart for arbitration. I'm the managing partner of Namara Musinguzi and Company Advocates, and I'm privileged to be here. My senior colleague Mohammed has ably taken us through Section 34 and the grounds for setting aside an arbitral award. And as Robert pointed out, the opening statement is only if the applicant furnishes proof that they fall in any of those grounds that are listed. There are many grounds that are listed, but over time, in the recent cases, we've seen a ground stand out that is called bias. But when you look at that law critically, Section 34.2, bias is partiality that people now call bias. So what is this evident partiality thing as a ground for setting aside an award? It is premised on the principle of natural justice. Everyone needs to be heard, and they need to feel that they have appeared before an impartial tribunal. And because of this, if there is anything pointing to impartiality or any inclination in favor of one party, courts, even though they are hesitant to open up awards because of the principle of finality, have gone ahead in certain instances to open up the award and set aside the award on grounds of bias, but only if the party alleging it furnishes proof. We need to note that it is more than a feeling. I felt condemned, or I was not given the attention I needed. No, it is more than that. You need to actually show court that the arbitrator did not listen to me. The arbitrator is known to the other party, and because of that knowledge, the award was influenced. So there needs to be a nexus, a connection between the bias and the final award. So according to me, this is one of the hardest grounds to prove, because it is extremely hard, if not next to impossible, to get evidence actually showing that the arbitrator was evidently biased. And what's the test? The test is, one, the reasonable man test. Could a reasonable person, a reasonable third party, could they have seen that actually there was evident favor of one party over the other? That is one of the tests. And the second test is, because of that favor, was the award given in favor of a party who should not have got it? So we're going to look at some cases. And I have my reservations for some of them, because the courts have gone ahead to apply the principles and stated what bias is, and then gone ahead to derail from their very own principles in some of the cases, as we're going to see. Councillor Muhammad mentioned the case of Kilembe Mines versus BM Steel Limited, which to me is a locus classicus on what bias is. It was a dispute. A dispute arose from a lease and provision of services agreement, and The respondent was aggrieved and went to court and said that the arbitrator did not give due attention to their counterclaim, specifically the special damages that it had pleaded and proved. It did not give it the same attention as it did to the claimant's special damages. So this is what the respondent said. He said, had they given me the same attention, they would have found that actually I had my grounds that my special damages were the ones, but he casually, actually the respondent said that the arbitrator casually considered the claimant's special damages claim. He did not ask the same questions as he asked the respondent. And because he casually considered the claimant's special damages claim, he awarded the claimant special damages. And when the respondent applied to set aside the award, the court found that there was evident partiality. And where was the evident partiality? Had the arbitrator, according to court, been keen, they would have seen there were dual figures. There was a repetition of figures that had been put in the special damages claim by the claimant. But because the arbitrator just breezed over them, he did not see them. And so the end result was the claimant being awarded more than he should have been awarded. Whereas the respondent, on the other hand, his claims for special damages were not considered at all. And the court said that had there been a more than casual scrutiny of the claimant's special damages, then they would have seen that there was a problem. And the court went ahead to say that that was evident partiality, or what we call bias, basing on the record. The record in this case was the special damages and how they had been pleaded. We have so many other cases coming after that follow the same principles, but in my opinion, digressed a bit from their application. And one of these cases is the case of Rocco and Kovsinje Janat, and it was a dispute arising from breach of contract. The respondent counterclaimed for breach of contract. And during the pre-hearing of that case, the parties agreed to a site visit and said that they would visit the hotel just to put the matter in context. And that is what was on the record. They were going to visit the hotel just to put the matter in context. So after this visit, as the arbitrator wrote her award, she referred to the site visit. Please note that no party had laid evidence from the findings arising from the site visit. But the arbitrator in her award said even the site visit showed that there was breach of contract. And in their application to set aside the award, the claimant, because the claimant in this particular case lost the arbitration, all their grounds were dismissed. They lost it on all grounds. So they applied to set aside the award. And the court said, after stating all the principles, what is bias, it must be apparent, it must not be speculative. After stating all the principles, the court said something which was very disturbing in my opinion. The court said that merely because there was a procedural irregularity or a procedural error in hearing, or some evidence was not taken, that itself cannot prove bias. And this is totally contrary to what we know bias to be. There should be no manner of inclination or favor of one party. But the court said that merely because these grounds were present. If there was no nexus to the award being given in favor of the winning party, then the person could not plead bias. So in this case, the court said that there was nothing to show that just because the site visit was mentioned in the award, just because the arbitrator relied on the findings of the site visit without considering evidence of the parties, that does not mean that her final award was influenced. In my opinion, I think had the court been a little bit more keen in extrapolating just that part of the award that talked about the site visit, they would have seen that actually that part of the award basically agreed with the respondent. It agreed with the respondent's submission, and it corroborated the respondent's submission with that site visit report. But the court didn't have any of that. It said the test for bias is stronger. It must point to the claimant or the applicant in this case having suffered an injurious award because of that claim. And whereas I don't agree, that was what the court ruled. And in the case of Aya Brothers, which Counsel Muhammad had mentioned, again, the issue of bias came up. The bias was, just to note that this was not a setting aside. This was an international arbitration. And although the parties, one of the parties had brought an application for setting aside, the court said that that was moot. However, they considered the grounds for enforcement because one of the limited powers of the court under the Arbitration and Conciliation Act is to enforce an arbitral award. So they considered the grounds of enforcement available to the parties because Uganda is a signatory to the United Nations Convention on the Recognition and Enforcement of Foreign Awards. This award this arbitration had taken place in South Africa. It had been conducted by the South African Arbitration Foundation. And so one party had applied to set aside, the other party had applied to enforce it. And the court said that one of the grounds for denial under that convention, one of the grounds for denial of enforcement is if it is contrary to public policy. Now, in this case, the applicant argued public policy from the point of bias and said that it was contrary to public policy to allow an arbitrator who was a founder member with the claimant law firm in the Arbitration Foundation of South Africa to handle the arbitration because there was no way a reasonable person would have said there was no bias. But then the court went ahead and said that arbitrators are people of some standing in this society. They are people of certain repute. They are people who have a lot of connections and a lot of competence. And because of that, that is why they are chosen. Otherwise, any person would be able to be an arbitrator. So because of their position in society, it is impossible for them to operate in a vacuum. You cannot say you're an arbitrator and you don't have any position in society. So the court in this case said that there was no link between that membership, that relationship between the claimant firm, the respondent firm rather, and the arbitrator. There was no link to show that because of that relationship, the award had been given in favor of the respondent in this case. And the court there said that it must not be remote. The bias must not be remote, but you must be able to show that actually. But what is very interesting is that the same court, about a month or so later, in the case of Smile Communications and ATC, went ahead and imputed bias on the arbitrator just because he had dedicated a book to the firm that was representing the claimant in the arbitral proceedings. So it's just important to note that the arbitrator during the arbitral proceedings, as is required of him under Section 12 of the Arbitration and Conciliation Act, he had declared that so many years ago he had worked for the firm representing the claimant, the respondents. He had worked for the firm, and he had declared, and they had gone ahead to allow him to handle the arbitration. But it is after the fact that there was a problem, because court said any bias, even if it's known to you during the arbitration, should be brought to the attention of the parties. And in this case, the court said, in my opinion, they descended a bit too low because they tried to make a distinction between an acknowledgement and a dedication, and said if that firm had been acknowledged, the acknowledgement that comes in, I think, in the last pages, if they had just been acknowledged, it would not have been important. But because they had put it just below the family members of the arbitrator, the book had been dedicated to the firm, the judge said that there was evident partiality, that it was impossible for a reasonable person fail to make a connection of bias. And it takes us back to Section 34, where the opening statement is they must furnish proof that there was evident partiality. Now, the judge in the Smile Communications case, as he always does, presented all the grounds. He had a very in-depth presentation of what bias was and what bias was not. And again, he stated the same grounds as in Aya Brothers, that arbitrators cannot operate in a vacuum because of by virtue of their position. But he went ahead and said that the fact that this book dedication closely mentioned the claim that the firm representing the other party, ATC, I think, then that meant that there was no way impartiality could not be imputed on the arbitrator. I did not see in that case the judge showing us the connection between the relationship and the final award. And also, I did not see him showing us the connection that because of the relationship, there was an inclination to favor the respondent. He did not show that in Kilembe, the connection is very clear. The judge showed that had the arbitrator read the special damages properly of the claimant, he would have seen duplicity. There, the connection was made. In the case of Smile Communications, I would like to suggest that there was no nexus between the final award and the fact that the arbitrator dedicated a book to the respondent law firm. So as I conclude, I would like to ask a question that what then is bias? What then constitutes evident partiality? If a connection cannot be made, can that still be evident partiality? But also, most importantly, if the courts have raised the bar a bit high and said, not every procedural irregularity, not every lack of calling of evidence can constitute bias, does that not present a circumstance where actually people will be biased, will actually genuinely have experienced bias, but because in the court's opinion, it is so minute to be considered, then the award will be upheld. So over to you, Robert. Thank you very much.
Thank you very much, Anne, for such an erudite covering of the landscape on bias. And your question on what is bias is not one that I am going to attempt to answer. But you have done us very well in bringing out the authorities, in covering the terrain, and especially in doing so while watching the clock. Very well done. I am looking at the chat to see if there are any questions, and I don't see one just yet, but if I am missing any, the panelists.
Robert, I'd like to say something.
Yes, hi, Rabina.
Yeah, I think Anne did a great job, and I just want to go back to what I said, that during the pre-hearing, you still have a chance to tell the arbitrator that you feel he's too close to part of either the subject matter or the parties. And that's why it's important when you're choosing counsel, when you're outsourcing, to bring people who can tell you without a shadow of a doubt that you can't bring somebody who, like the arbitrator for the one with the book, and also, I forget what case that was, who dedicated a book. Most people would, actually, the arbitrators themselves would say, no, I don't want to threaten your award. I will not be able to take this matter. So the arbitrators also have to raise their own standard and say, you never know, this could jeopardize the award. Let's look for somebody else. And that's what you see in many of these. Somebody says that I used to play golf with somebody 5 years ago. And they're like, because of that, I won't be able to handle this matter. You need to have the advice within the team of lawyers to insist that they get the very best for their client. And you can't just sort of say, well, this might go through, this might work, because this is binding. There's no other, nobody's going to open up the record, like the incident with the hotel. Nobody's going to open the record to see what happened in the site visit, what happened. The court will distance itself from even listening to those kinds of submissions, because Section 34 is saying that it's actually just about the arbitrators and the bias and the impartiality and the excessive acting beyond the scope of their mandate. So I think the courts are just being careful to say, look, be autonomous. We don't want to interfere with the facts and the law. We just want to interfere if there's some aspect of public policy or some amount of unfairness on the part of the arbitrator's conduct, rather than trying to drag us into the substance when you're the one who chose your lawyers, you're the one who chose the arbitrator. And so you've got to try at the pre-hearing to be as tough as possible and just until you get the right person, until you get the right team, the best lead counsel. Fly somebody in if you must, but it's better than having your award set aside.
Thank you, Robina. Robert, if I may.
Yes, and while you do, Anne, let me just add one more to you. There is one more question from the chat. Someone is asking you, at what point arbitration proceedings commenced, and have the courts or the law determined the exact document that commences arbitration? But go for it. Okay,
thank you, Robert. I needed to answer Robina. Robina said the courts are reluctant to open up their award, and I agree, because it's by its nature, it's fine. But what we're asking for is consistency. And that is what we are failing to see in these decisions. We have failed to see them consistently apply their own principles of evident partiality. In one case, they will apply them. In the other case, they will totally disregard them. And if you ask me, that is what happened in the Aya case and in the Smile case. Same principles, totally different applications. Then when does arbitration? Yes? When does arbitration commence? I think that was a question. What commences arbitration? First of all, there has to be a dispute. Not everything amounts to is a dispute. What does the arbitration clause say about a dispute? So to answer your question, the arbitration proceedings commence when the parties have identified a dispute, not a misunderstanding. There could be misunderstandings that could be resolved by court according to your clause. So it depends on what your clause says. So if according to your clause, you have identified a dispute, that is when the arbitral proceedings commence. And secondly, what's the second procedure? You write. You, the aggrieved person who has identified the dispute. Okay, depends on the arbitration rules, but usually what cuts across is the person who has identified the dispute will write to the other party and say, and quote the clause of the contract from where the arbitration jurisdiction comes from, and says, according to this section, there was a breach, and according to this section, it's an arbitrable breach, and I would like to commence arbitral proceedings. So that letter will commence the proceedings, and subsequently the parties will go ahead to agree on the arbitrators, the number according to their rules, or according to the laws that are governing them. I hope I've answered.
I believe you have, and perhaps just to add, some of the rules might stipulate different kinds of what the founding document is. So whether it's the statement of claim or the request for arbitration may really depend on which rules you put in your clause. But this is a very good time for us to transition to David. And David, as we transition to you, Anne has touched, we take it back from where we started. Robina has teased out a number of things about how the process starts and continues. Mohammed did touch on various aspects and the grounds, and I think one of the ones that he was sort of, the iron he put in the fire quite firmly was the one on public policy. So now we have public policy, now we have bias, we have section 34. Just give us sort of paint for us the panorama on what are the other grounds and how do they all play together? Must you plead more than one? Do you need all of them? Where are the courts going? Have the courts gone too far? Are they doing it well? I can't think of a better person to take us from where we are now to you, my good friend of many years, David. Over to you.
Thank you, Robert, and thank you, dear participants, for joining in on this webinar. I'll go straight to the point on setting aside. I'm going to talk about public policy. For a very long time after the promulgation of our constitution, there used to be what they used to call the lazy lawyers article. It was Article 126, Clause 2E. It's one of those articles where if you had no grounds to argue something, or if you are out of time in an application, you just pull out Article 126, Clause 2. And somehow maybe a judge will help you to say that substantive justice has to be done without undue regard to technicalities. Well, now, it's now becoming common that when you're trying to set aside an arbitral award and you don't have valid grounds or serious grounds, you say public policies, like the new Article 126, Clause 2E. Because public policy has not really been defined, and it is not static, it changes. For example, in our Advocates Act, we have offenses like champate and maintenance. But in Nigeria, where they had similar offenses, they have amended their law and it allows champate. So it's no longer contrary to public policy. So it is something which is interpreted differently by different judges. But one of the key decisions where there is an attempt to define it is Lakeside Dairy versus Midland Emporium and ICAMEC. Justice Mubiru labored to explain public policy and said that it is that one which prohibits abuse of contractual or legal rights, the principle of good faith, the prohibition of expropriation without compensation. Yes, this is well entrenched in our constitution. Prohibition against discrimination, principle of proportionality, protection of minors. Clearly, these are things which an arbitrator would not even delve into in making decisions. So whereas the description was quite clear, I'm still surprised that in the case of Uganda Development Corporation versus Rock Trust Contractors, the same judge partially set aside an arbitral award on the basis of public policy, but for entirely different reasons. And I'll explain the reasons. The arbitrator had awarded a certain amount of money under the principle of quantum merit. Basically, it was a construction dispute, and the employer had instructed the contractor to execute works which were outside the contract. The contractor executed the works, and the employer was happy with the works, but did not pay for them. So the contractor brought an action, and he relied on the principle of quantum merit. And the arbitrator, relying on various decisions, common law and various decisions of the courts, allowed this remedy under the principle of unjust enrichment. So this matter came before Justice Mubiru, and Justice Mubiru said, well, the arbitrator was alive to the legal principles. The principles of quantum merit are valid principles of law. However, there are PPDA regulations which say that if a variation exceeds a certain percentage, you need to go and get the contracts committee to approve that increment. And the fact that there was no contracts committee that approved that increment, the award to that extent contravened public policy. That's what it is. So the nature of arbitration that we're having now is that you can find that they are contradicting decisions, but based on the current Arbitration and Conciliation Act that we have, the High Court is final. So even if there's a contradiction, we'll live with it. So that is one of the aspects. The other aspect that is quite common now is people bring applications saying that the arbitral award is contrary to the law. And many a time they rely on Article 28, of course, the fundamental right for fair hearing. There's a decision, it involved Prism Construction and Dongil Construction. It went before Justice Anna Mugenyi. she set aside an award on the basis that the arbitrator had struck out a witness statement. Now, Section 25 of the Arbitration and Concession Act allows arbitrators to proceed ex parte if one of the parties is not participating in the proceedings, notwithstanding the fact that they were served with pleadings. And a number of these cases actually confirm that position, the power of the arbitrator under Section 25. The I Investments case clearly shows that I Investments were not participating in the proceedings, but they were served with all the procedural orders, they were served with the pleadings, they were served with hearing notices, and they just did not respond. So Justice Muguru was correct when he said that failure to respond does not stop the arbitrator from proceeding to make a decision, notwithstanding that it's ex parte, because you've made a choice to remove yourself from the jurisdiction of the court. So, but in this case of Prison Construction versus Dongiyo, the judge seems to say that the arbitrator did not have a right to strike out a witness statement of a witness who had refused to come and attend the tribunal, notwithstanding the fact that they had been served a number of times. So the scapegoat there was Article 28, that the fact that a witness statement had been struck out, a party was deprived of a chance to present their case, and somehow they succeeded to set aside that award. So one other aspect I want to talk about is the aspect of the bias. Of course, Anne has done a good job, and my previous presenters, Mrs. Shinobi and Senior Counsel Babazi, they've done a good job to explain these principles and the examples they have given. I just want to add one thing for the benefit of all of us. Sometimes when courts are faced with aspects of bias, they rely on the International Bar Association guidelines on conflict of interest. They kind of provide a parameter where the courts have a basis to make a decision whether someone is biased or not. These guidelines are free, a free download. You can download them from the IBA website. But in essence, they provide three categories of disclosure that an arbitrator ought to give or doesn't have to give. There's the red list, which shows examples where, for example, an arbitrator is a shareholder in one of the parties. Obviously, they just cannot arbitrate that. It's not a question of disclosure. It's actual bias. So it can lead to setting aside an award. And then there is the orange list where, for example, a party appears, but maybe you had represented them some time back, or it was there wasn't really a very close relationship, or it's a client that had been represented by one of your partners previously, but you did not benefit from the transaction. Or maybe you were a clerkship student in a firm that has appeared before you. These are things that you ought to disclose to the parties so they can waive them. If they don't waive them, then obviously you cannot proceed to act as arbitrator. And then there's a green list. The green list are things which are in your knowledge as arbitrator, but you need not disclose. For example, I'm a member of the Chartered Institute of Arbitrators, just like, for example, Anne and Robert and any of the people here online. So I don't need to disclose that if I'm an arbitrator, that I'm a member of the Chartered Institute of Arbitrators with one of the lawyers. It's in the green list. It need not be disclosed. Membership in professional organizations. So you realize that some of these guidelines come in to help the courts in deciding some of these aspects of setting aside on the grounds of bias. But there's a very interesting English decision. It's called W Limited versus MSDN, where an arbitrator was a partner in a law firm, and that law firm was representing a subsidiary of one of the parties. Let me put it differently. An arbitrator is a partner in Kagwa Advocates, and Kagwa Advocates represents Wava Water, which is a subsidiary of the Spear Group of companies. So you realize that the arbitrator is not directly handling the matters in the firm, but it is other partners who are actually representing the holding company of the subsidiary, which is a party to the proceedings. So in essence, there wasn't direct conflict, but the fact that the party was a subsidiary of a holding company, which their firm was representing, a party brought an action, set aside an award. And during those proceedings, the court allowed the arbitrator, in very rare circumstances, to just present a statement about the allegations of bias. And the arbitrator disclosed that he was no longer an active partner in the firm, that he had retired from actual practice, but that he remained a named partner in the firm, but he never sat there. But he was using the firm for secretarial purposes where his documents had dropped and so on and so forth. And that he was not taking any dividends or any payment from the firm arising out of the firm work. And actually the court said that there was no bias. He said, notwithstanding the fact that he was a partner in a firm that represented the holding company, you have to show actual bias. You need to show that the arbitrator is a beneficiary from the transactions between the subsidiary and the law firm. So, but the benefit of the decision in Lakeside was that Justice Mobiru gave guidelines that when you're applying public policy, the courts must interpret it narrowly. So it shouldn't be given a very wide perspective. Otherwise, it will give a room for people to abuse it. So you realize that a big part of the proceedings on setting aside are hinged on this aspect of public policy. So even the Alcon case, you realize that whereas the late Justice Sarah Chamoko had confirmed the award, it had gone to the Court of Appeal. And then as the Alcon brothers were fighting, that's when it became apparent in the affidavits that there was an assignment of the contract without the consent of NSSF. And then somehow the allegations that there was fraud. And then you realize that now at that point, the Supreme Court, while setting aside that award, made serious findings of public policy. So in essence, any act of fraud can be construed to be contrary to public policy. Thank you for listening to me. Over to you, Robert.
Wow, David, thank you for giving us a very good layout of those decisions and where they take us. Fantastic considerations and what happens there. But I want to be the first to ask you a question. And again, to our participants, to our members who are attending, if you have a question, please drop it in the chat. Our panelists have used their time very, very wisely. We still have good time to go into a Q&A. The reason why we chose the format we did was because we suspected we might have issues with time. But I'm sure that I speak for everyone on the call when I thank every one of our 4 panelists for a job very well done. David, I saw a decision recently where Justice Mobiru set aside the award simply because it was rendered beyond the time that the parties had agreed. Is that a ground for setting aside? And also, what happens where it is perhaps I'll leave it at that, but also, in your view, thinking through public policy, the way it's been handled in the decisions you've gone over, are we safe? Is this ship in the harbor, or are we likely to see a bit of an upset? I like the way you considered Justice Mobiru's approach and the way he contradicted himself. can we say the ship is the public policy side?
Thank you, Robert. First, your question, when question about the award that was set aside, I'm sure that is the Smile Telecom Award versus ATC, because the arbitrator had exceeded the time for delivery of the award. My comments about that. Robert, it's neither here nor there. One, I'll start with the law. The law provides that an arbitrator ought to deliver their decision within 60 days from when they are called on to hear the dispute. Now, the same act provides the procedure for exchange of statements of claim and defenses. Now, if you have 60 days within which to make a decision, and I need to tell you members, I am an arbitrator. I have never been able to deliver an award within 60 days, just because of the timelines. Most parties who appear with their lawyers have litigation at the back of their mind. So when they appear, for example, when you are appointed, now you need to send out summons for a preliminary hearing for the parties to appear before you. So you need to give them ample time to hire lawyers or to prepare to come. So the earliest you can give them is maybe 7 days. So if you've been appointed 1st of August, so the earliest you can have the preliminary meeting, say 8th of August. So when the parties appear for the preliminary meeting, then that's when you agree on the law applicable, the seat, the procedure, filing of pleadings, payment of fees. So all that, you reduce that into a procedure order. Now, at that point, the parties are at liberty, because of party autonomy, to decide the time when they need to file their pleadings. You can't tell them file tomorrow because you're not a court. So usually the parties ask for 2 weeks each. So 2 weeks plus 2 weeks, that's already 1 month and 7 days. And then usually, because of litigation, parties want to file a rejoinder. So another 7 days. So you're already in 1.5 months just to close pleadings. Then you will need to have a case management conference, which is like a scheduling conference, which happens like a week later. The 60 days are done by the time you do the case management conference. But then the same law says that the arbitrator is at liberty to enlarge time from time to time. That provision does not say you need the consent of the parties. It is an inherent power of the arbitrator to extend time as they deem fit. But of course, not to an extent that it loses meaning, but you have the right and the powers to extend time. So on one hand, I would respectfully disagree with the decision in Smile Telecom, where the judge set aside on the basis that the award was outside the 60 days. It's not practicable to give it an award in 60 days. And the act empowers the arbitrator to enlarge time. That's one. But then two, where the judge may be right is that the agreement expressly provided that the arbitrator shall make a decision within 60 days. Now, Justice Mobiro has been very categorical in a number of his decisions. There is one that Anne has discussed, the one of Rocco Construction versus Kovsinje. It was about the dispute of Mestil Hotel. In that decision, Justice Mobiro rightly said that the jurisdiction of an arbitrator is derived from the contract. That an arbitrator does not have inherent jurisdiction, just like the courts do. So you need to specifically read the contract and see what kind of jurisdiction you have. But then the same judge has said that there is a concept called sweeping jurisdiction. That even if a contract doesn't expressly give you jurisdiction, if the parties have raised issues and they have responded to those issues, and those issues are before you, even if they are not expressly in the contract, you have jurisdiction under the concept of sweeping jurisdiction. So on one hand, the same judge says, restrict your jurisdiction to what the contract says. So if you are to strictly rely on what the contract says, if you exceeded the 60 days, yes, you may not have jurisdiction. But if you rely on the same judge's concept of sweeping jurisdiction, it is the same parties who kept you busy, even beyond the 60 days. Wouldn't Section 4 about waiver apply? I would think it would. So, Robert, I hope that answers your question. Over to you.
Yes, David, indeed. That is a good way to look at it. So perhaps the good judge will have an opportunity to reconcile his decisions soon enough. But at this point, I'd like to ask anyone who has questions, and also the other panelists, if you want to jump in and supplement on any part of the conversation. We still have 21 minutes to go, so I believe we're good for it in terms of time. And if anyone has questions they'd like to raise, this would be a good time.
Robert?
Hi,
Robert?
Yes, Robin,
Hello?
I can hear you. Please go.
Yeah, I saw a comment
Yes,
from Lydia Ochengobo, and
yes.
That's a very good example of a firm or lawyers that are diligent in confirming whether this arbitrator can actually protect the award to the end, because she says that she had been working for the bank. I think maybe the bank was the plaintiff, or I don't remember what it was, but she said she had a relationship with the bank, and the lawyers came back and told her, sorry, we think it would be detrimental to our award. So that's the kind of practice you want to encourage, where the arbitrator discloses and withdraws, and the lawyers also agree that, no, we don't think you are the right person. When you insist on a gray area, you're threatening your own award. So I'm glad we have an example where our own firms and arbitrators can stand up and uphold the standard. That was very encouraging. Thank you.
Yeah, thank you very much. I see that Lydia has raised another question, and great to have you on the call, Lydia. If I might say so myself, Lydia is actually a fantastic arbitrator in her own right. I say that, yes, I say that because I know that people who recommend appointments and people who appoint arbitrators are on the call. But yeah, so just to add, Lydia has raised another question. What happens in the cases where the award has been set aside? Is that the end of the matter? Any of the panelists can take that one. Do we still, I'm not quite sure if we still, David, do you want to take that one? Or is Mohammed still on the call? Sure, go for it.
Yes, I want to take that one on what happens where an award has been set aside. There was a decision of, let me just get the actual parties, but the Kirembe Mines and BM Steel, I'm going to type the full details there. It was a decision by Justice Egon Antende while he was still at the High Court, where he set aside an award. And in his concluding remarks, Robert, if you can just give me, it gives the answer exactly the way it is. The judge said that there is a dilemma for the parties where he was after setting aside. Do they commence new arbitral proceedings before another arbitrator, or do they commence an action in the court of law? The Arbitration and Conciliation Act is silent on consequential orders to be made by the court after setting aside an award. I leave it to the parties to determine their next course of action. So you can imagine a judge who is supposed to guide us, say that the parties can go and find out what they should be doing. But anyway, the decision of Rocco Construction and Janet Kousinje, which was argued by my sister and Musingo Zinamara, the judge set aside the award of general damages on the basis that the arbitrator did not have jurisdiction under the contract to give anything other than liquidated damages. And then the judge went ahead to remit the award back to the arbitrator to correct what the judge had set aside. I found that an academic exercise. Then also another thing was the Alcon case, which went to the Supreme Court, Alcon and NSSF. So the Supreme Court set aside the award and then remitted the dispute back to the trial court for hearing. That one may be a little bit clear because now there was no more arbitration clause. So therefore, their only recourse was litigation. But a silent issue that I see here is limitation. My view is that where an award has been set aside and there are no consequential orders, it does not nullify the arbitration clause unless the court has specifically said that the dispute is not arbitrable, or the court has actually said there was no arbitration agreement, like in the Alcon case. But if the judge has not made any mention nullifying the arbitration agreement, or the judge has not made a declaration that the dispute is not arbitrable, my view is that based on the fact that the arbitration clause is still alive, you can start the process up fresh, subject to the law of limitation. Now that means if it's breach of contract and it has exceeded 6 years, you've been in the courts and the 6 years have lapsed, you lose your right. Over to you.
Thank you very much, David. And I see that there's another question for you, actually. Someone says, David, from Dennis Lukambi. I hope I'm reading that name right. And Mr. Lukambi is saying, David, kindly educate us on the matter of payment of arbitrators' costs. If one party refuses to pay, does the arbitration proceed or the other party pays the entire cost?
It depends. Most lawyers answer questions that way. It depends. Yeah. I think, Robert, when you get clients calling, you always tell them it depends. Yeah. So this is why it depends. One, if it is institutional arbitration, for example, the arbitration clause says that the arbitration will be governed under the LCIA rules or ICC rules or the ICAMEC rules. Those rules are very elaborate. Those institutions go a long way to solve all these challenges that we have in arbitration. So if the arbitration clause has an institution, usually those institutional rules have an answer. And the answer usually is that each of the parties is jointly and severally liable to pay the arbitration fees. What I mean is, if there is Alcon on one side and NSSF on the other, and the arbitrator's fees to be paid is 100 million shillings, NSSF has paid 50 million, Alcon has not paid. If you want that arbitral award to be delivered to you, you must pay the difference before you access the award. So institutional arbitration has that advantage. It safeguards the arbitrators and the parties from a lot of uncertainties that arise from such issues. So jointly and severally means whoever wants the award so badly, pay 100%, pick your award. Maybe there is an opportunity for you to recover what you've paid from the other party. That is if you've won. If you haven't won, the loss falls where it lies. Now, if it is ad hoc arbitration, whereby there are no institutional rules, it depends on the practice. And I'll tell the parties what I do. On day one of the preliminary meeting, I make sure that the parties sign procedure order number 1, which has the fees that we've agreed upon. And I always put a clause that each of the parties is jointly and severally liable to pay the arbitrator's fees in full. So in essence, I explain to the parties that if one party doesn't pay, the other must pay the whole amount. They are at liberty to recover it from the other party. Over to you, Robert.
Thank you very, very much, David. And I think you have really tickled people's minds. Patience Akamprira, who, as I'm sure you know, is a member of the Chartered Institute, raises a question. What is your position on the need for leave to appeal against a decision of the High Court setting aside an arbitral award to the Court of Appeal? Mbale Resort and Kilembe Mines seem to have contradictory positions. And she addresses it to you, sir. Over to you, David. Oh, and then there is another one. The second one from Julius Ainomsha. If an award is set aside, but I think that's the one David just answered. If an award is set aside and the parties have to start afresh arbitration proceedings, how many times can these fresh proceedings be done? Can it carry on forever?
Let me take Patience's question. What is the position on the need for leave to appeal against a decision of the High Court setting aside an award to the Court of Appeal? Mbale Resort and Kilembe Mines seem to have contradictory positions. Now, Patience, the law is now settled by the Supreme Court. Mbale Resort went to this. The case is actually Babcon versus Mbale Resort. It went to the Supreme Court, and the Supreme Court made it categorical that the Court of Appeal and Supreme Court have no jurisdiction, appellate jurisdiction, or any other jurisdiction in arbitration matters. In essence, the High Court is final in regard to matters arising out of the Arbitration and Conciliation Act. There is only one exception, and that exception is under Section 38 of the Arbitration and Conciliation Act, which says that where the parties agree and they obtain leave from the court, they may appeal on a point of law. So in essence, you must satisfy two ingredients. The first ingredient is there must be written agreement by the parties. Number two, then you seek leave. So seeking leave alone, the court will not have jurisdiction to grant you that leave if you don't have agreement of the other party. But now the Mbale Resort matter was very, very interesting, because a certain party made an application for leave to appeal, and opposite counsel said, I have no objection. And then Justice Monda, the Supreme Court, said that amounted to agreement. In essence, having no objection to an application for leave, according to Justice Monda, amounted to agreement to appeal. And according to her, the two ingredients were satisfied. So in a nutshell, there is no right of appeal from the High Court to the Court of Appeal. The only exception is under Section 38, if you can satisfy two grounds: agreement of the parties and leave of the court. Robert?
Thank you very, very much, David. You have done us well in distinguishing those authorities. Now, Olive Zale Otete has raised another question. Should the parties agree on a date for handling arbitration proceedings which exceed the time set under Section 31(1) of the Act? Mohammed, do you want to take that one?
Mohammed had to step away, so if any of the panelists could do that.
Okay. Over to the rest of the team that we have on this evening. Anne, do you want to go for it?
Thank you, Robert. Let me answer it. Yes, the parties should agree on the date for handling arbitration proceedings which exceed the time, and that is what happened in the Smile. I think it's in the Smile case. Yes, Smile Communications. They went beyond the time, but they kept on extending the time for the arbitration proceedings to end. Actually, the final extension is what brought a problem for the judge to set it aside. But to answer this question, yes, parties need to agree. Time is set by statute, but as David explained, those days are not enough. But as long as the parties agree, remember, arbitration is based on party autonomy. As long as the parties agree, then that time can be extended. Thanks.
Fantastic. Excellent. So I happen to agree with you on that point, Anne. Very well done. So I don't see any other questions in the chat. If anyone has a question, please let us know. We're happy to bring it to the panelists at this stage. But as we are now entering the last minutes of the call, again, I just want to take a moment to appreciate Mr. Muhammad Mbabazi, our senior colleague, Mrs. Robin Ashonubi, Mrs. Anna Maram Singuzi, and Mr. David Kagwa for taking the time to prepare. I think it's quite clear. I've tried to follow the chat as closely as I could, but I hope that everyone on the call will agree with me that the panelists put in the time to prepare adequately to go through the authorities to take us over, by my count, at least 12 decisions. I'm just looking at the notes I scribbled, and I think we did exceed 12 decisions on this call. And to distinguish them and to digest the material. I also want to appreciate and shout out to our colleague Godwin Tunamasiko at the Secretariat, who was really, really critical in putting it all together, and to my colleagues Michael Mafabi and Florence Nabeteme, who have been quite quiet on the call, but who are very, very active in spearheading the cause of arbitration. Just before I let each of the panelists give us a parting shot, I think I saw a question just now. It has now just disappeared from, now that I talked about it, it has gone away. But yes, here we go. Mr. Richard Omongole has raised a question, and any of the panelists can take this one. Robin, I don't know if you want to take it, or if David or Anne would like to take it. Is competence or of an arbitrator now a ground for setting aside? Does any of the panelists want to take it?
Sorry, what was the question?
The question is competence of the arbitrator now a ground for setting aside? What if you happen to have an incompetent arbitrator? What do you do?
According to Aishwarya Padmanabhan, he was evaluating Section 34. He said that the arbitral award is not open to challenge on ground that the arbitral tribunal has reached a wrong conclusion or has failed to appreciate facts or evidence. Thus, it has been well settled that the parties constitute the arbitral tribunal as the sole and final judge of the dispute, and it is outside the scope of Section 34 to query or investigate what you can't do anything about it. Section 34 can't help you on that. Yeah, because it's outside the scope.
Yeah.
So they have bound themselves as a rule to accept the arbitral award. And they can't change that just because the arbitrator was incompetent.
And if I might add, Mr. Mongole, I think the rules anticipate, or the law anticipates, that you would have considered that before you chose that particular arbitrator.
Exactly.
So the law presumes that you were alive enough to, which is why once you that vessel and you take off, you're stuck with what comes out of it. You can't even come and say the arbitrator. Yes, David.
Robert, just 1 minute. There was an arbitrator who made a decision. He was an engineer, and in his decision, he quoted a song by Kenny Rogers about the gambler. Do you know that song, Robert?
You've got to know when to hold them. I think that's the one, no?
That's the one. So he quoted that song, and in essence said that one of the parties ought to have known that he has made a loss and he should have walked away like the gambler. So Justice Okumuwengi, obviously that was a level of incompetence. Justice Okumuwengi got a polite way of setting aside that award and said that relying on the lyrics of Kenny Rogers is a misdirection of the law and is therefore contravened the laws of Uganda. So over to you.
That's an interesting one. But also tells us about how these things can play out. It's interesting that the questions keep coming in just as we are about to hit the top of the hour. And I do want to save a few minutes. I would request members on the call to allow just a few minutes for us to get parting shots from the panelists. But perhaps this would be the last one. David, Mr. Abdallah Mugaya asks a question. Can you comment on Section 26(5) of the Arbitration and Conciliation Act about the judge's discretionary powers to enlarge time for commencement of proceedings in case of setting aside the award where the limitation has caught up with the party?
Robert, Section 26(5) does not exist in the Act. 26 talks on 3, and it talks about experts. But I want to get the context from Abdallah. I think he wants to talk about enlargement of time to commence proceedings in case of setting aside. Now, setting aside, I don't know. So let's go to 34. Maybe he may have meant 34. Yes, 34 has 5, which says that if an application for setting aside or suspension has been made to a court, the court may, if it considers it proper, adjourn its decision and may also, on the application of the party claiming recognition or enforcement of arbitral award, order that the other party provide appropriate security. Well, it still doesn't answer, but I'll go straight to the point. The question is, does a judge have discretionary power to enlarge time for commencement of proceedings in case of setting aside the award where a limitation has caught up with the party? My answer is no. It's no, based on the fact that Section 9 of the Arbitration and Conciliation Act boosted the jurisdiction of courts in arbitration matters, save for where the court is expressly authorized. Let me put it this way. The court has no jurisdiction in arbitration matters, apart from only those sections which are explicit on the court's role. Stay of proceedings, injunctions, setting aside, enforcement. Anything outside where the court is expressly authorized, it has no jurisdiction.
Okay.
Yeah.
Thank you very much. So at this point, I want to say that it has been my singular privilege to moderate this panel, but I now want to go back in reverse order of how we started to get the parting shots from our panelists before we wrap it up. Perhaps maybe this time we start with Anne. Your parting shot. What would you like members to take away from this?
Thank you, Robert. Thank you, fellow panelists. Thank you to everybody who logged in. I hope you learned a lot about the entire arbitration process. And I would like that you take home that arbitration is still the best and easiest and cheapest way of resolving disputes. So go for it, knowing that you will get do not fear that there will be grounds under which your award will be set aside. Go for arbitration. It is still the best way and mode of resolving disputes. Thank you.
Thank you very much, Anne, and thank you so much for all your time and effort in giving our members a very, very good and robust session. Robina, your parting shot?
I agree with Anne. I think it's a very important way, and it's still adversarial. I know one of us said that it's informal, but it says adversarial. There's real pleadings. You still have a chance to plead your case and, represent your client in that closed private session. And lastly, I don't want to be the only one who hasn't mentioned the name Justice Stephen Mubiru. So I will say that on the last page of the Aya case, he says that there should be persuasive evidence of partiality rather than mere speculation or possibility or a vague appearance of bias. So you'll be saving your client and yourself time if you don't have persuasive evidence of partiality. Just find the money and pay do what you have to do and move on. Thank you very much, Robert. It's been a pleasure.
Robert, you are muted.
So sorry about that. I was just saying that I'm grateful to Robina for putting in the time and for her very invaluable contributions to this. Robina, I know that you and I have spoken at some very early and very late hours to put this together. And so I just wanted to shout out to you and say thank you very, very much. But now, David, over to you for your parting shot.
So I want to thank all the members of the Secretariat at Uganda Law Society for putting up this wonderful webinar, and you, the members of the cluster. And my fellow panelists, thank you for doing this. It's been worthwhile. My parting shots are very simple. I want to invite all of you who have not done any course of the Chartered Institute of Arbitrators. Please do it. The Chartered Institute of Arbitrators provides the gold standard for arbitration practitioners all over the world. It is one way you can be sure of having international recognition and having the knowledge that is necessary in this world. In this world where there are lots of businesses, lots of construction going on, lots of transactions going on, where economy is growing, by next year, our economy should be about $60 billion. Many of the investors like arbitration as the way in which they resolve their disputes for the advantages that Mr. Babazi talked about. So it's the best time for you to come and train. I'm available. I'm the chairman of CIAB. We have trainings this year. We have the accelerator to member this year. We also have the introduction course. Please come to us and attain the gold standard. Over to you, Robert. Thank you very much.
Thank you very, very much, David. And I will just speak in attestation of the training and the examination that the Chartered Institute offers. I would say to anyone on this call who hasn't taken the exam, I think it is worth your while. And to distinguish for you, if you want clarity on the distinction between arbitration and litigation, I think that doing that training would help you with that and the approaches that happen. Now, it is a lesson I learned from my very dear mother that all good things must come to an end and quietness follows. We are at that point where it is my singular privilege to thank every one of you for staying to the end, to thank the ULS Secretariat for putting it together. I know for a fact that there will be a session at the annual law conference on arbitration, which I think will discuss much broader issues than we've been able to cover on this panel. So please look out for that session at the conference. And I hope that you join us, and I hope that you have a good time. Otherwise, from me and the rest of the team, I want again to shout out to Michael and acknowledge my colleague, my colleagues Michael and Florence, with whom we lead the cluster, and thank them very much for their work. Godwin, I think now I must surrender to you. Thank you for leading us ever so well. And from me and the rest of the team, to everyone on the call, it's have a great weekend. And until then, cheers. Godwin, over to you.
Thanks, members. Thanks to the cluster and the panelists for putting this together and the attendants. We have put this on YouTube, so look out for the link in case you missed some bits or you want to recap. So you can go to the ULS YouTube page. You'll find the link there. We'll also be circulating it in a short while. Have a good weekend.